Darnell Washington was 29, building 3 delivery platforms, a new commercial kitchen lease, and a side business. His knee was essential to his income, so when he slipped on a wet tile floor at a licensed cannabis dispensary in Culver City in January 2026, the fallout was immediate. He didn't know the floor had just been mopped or that no warning sign had been left. An MRI confirmed a complete ACL tear in his left knee. Surgery was unavoidable. Recovery would take 8 to 12 months, and for someone who had to move, lift, and drive to earn money, this became a financial crisis as much as a medical one. While Darnell was still on the floor, the dispensary manager arrived with a standard incident report, calling it routine insurance paperwork. Darnell signed it without reading every line. Buried in paragraph 3 was a clause saying he accepted the premises were reasonably safe and agreed to hold the dispensary harmless for ordinary accidents. Within 72 hours, the insurer denied the claim, cited the signed form as decisive, blamed Darnell in part for not being careful, and offered just $8,500. It wasn't a real offer. It was a signal that they thought the signed form had already won them the case. Darnell quickly saw the numbers. He had $4,200 in savings, while ACL surgery would cost at least $22,000 and rehab another $6,000 to $9,000. He couldn't drive for weeks, run for months, or work normally for a long stretch. His 3 platforms brought in about $280 a day, so months of reduced capacity meant a huge income gap. His new commercial kitchen lease kept draining money while the business sat idle. The insurer's $8,500 wasn't enough to help. It was a pressure tactic. They were betting financial stress would push him to accept. What saved him was not luck, but the discovery that California law already undercut the waiver they were relying on. The first 3 lawyers all focused on the waiver. One said it could reduce recovery. Another said the comparative fault issue made the case weak. The third wanted a $3,500 retainer just to keep looking. All 3 treated the signed paper as the main obstacle. What they missed was that California law already had 2 separate legal rules that could wipe out the waiver completely. The document wasn't just questionable, it was likely unenforceable from the start. The dispensary had handed Darnell a form that state law may already have made worthless, but that only mattered if someone knew where to look. California Civil Code 1714 requires property owners and occupiers to use ordinary care. A freshly mopped floor with no warning is a clear breach. More important, 1668 says contracts that try to excuse someone from liability for breaking the law are against public policy and void. That matters because a licensed dispensary must follow safety rules under Cal OSHA, including keeping commercial floors reasonably free of slip hazards. If they mop and leave no warning, that is not only negligence but also a statutory safety failure. Under SS 1668, a business cannot sign away liability for that with a clipboard form, fine print, or an injured customer signature. Even if 1668 didn't apply, the 1963 case Tunkl v. Regents of the University of California gave another way to strike the waiver. Tunkl says liability waivers can be invalid when a business is heavily regulated, offers services to the public, and uses a take-it-or-leave-it contract. A licensed cannabis dispensary fits that framework closely because it operates under state oversight and serves the public. Handing an injured customer a release while they are on the floor in pain is the definition of an adhesion contract. Either SS 1668 or Tunkl could kill the waiver on its own. Together, they made the insurer's defense legally fragile from the moment the form was signed. The insurer also tried to argue that Darnell was partly at fault, but California uses pure comparative negligence under Levy Yellow Cab. That means fault can reduce recovery, but it never eliminates it. Even someone found 99% at fault can still recover 1% of damages, so blaming Darnell for not watching where he stepped was never a total defense. At most, it was a way to lower the payout. And to make that argument work, the insurer would have to prove he knew about the specific wet floor, not just that floors can be slippery. They had no evidence for that. Darnell's 4th attorney acted fast and sent the litigation hold notice before security footage could be erased. The dispensary had 16 cameras, and the video showed everything. The cleaning crew mopped the area, left without placing a warning sign, and Darnell slipped about 12 minutes later. Then the maintenance log became even worse for the dispensary. It showed 2 earlier slip incidents in the same spot, one in March and one in July 2025, both after mopping. Staff had documented them, but no warning system was put in place afterward. That turned the case from an accident into a known recurring hazard the business ignored. The court granted the motion to void the waiver, applying both SS 1668 and the Tunkl analysis. The comparative fault argument also collapsed because the footage showed Darnell couldn't see the wet floor, no sign had been posted, and the prior incidents proved the dispensary knew the danger existed. A forensic accountant calculated lost income, and an orthopedic surgeon projected future medical costs and long-term risks like early arthritis. The insurer's offers rose from $85,000 to $195,000 to $285,000, but all were rejected. The case settled for $340,000. The waiver that had been treated as decisive in the first denial letter ended up meaning nothing. The real lesson is bigger than Darnell or this dispensary. California law had already given him protection through 1714, 1668, Lee v. Yellow Cab, and Tunkl before he ever fell. What he lacked was knowledge, and insurance companies depend on that gap. They use paperwork that looks official, hope people sign without meeting, and rely on the fact that most injured people don't know a waiver may already be void. So if anyone ever hands you a form after an accident, don't sign it blindly. Read every line and ideally get legal advice first. The paper may look powerful, but under the law, it may already be worthless.